This is much like shooting the side of a barn and drawing the target around the bullet holes and then proclaiming bullseye. Good morning, everybody. And sorry, give me just a second. Floor's not entirely level in here. You guys should see what I have to do to keep this desktop level. This is beside the point. The ATF has decided that they are going to be appealing their loss in the pistol brace situation. So that whole thing where they decided to unconstitutionally infringe on your Second Amendment rights that are enumerated in the Constitution and illegally change definitions of legislation that Congress has passed for the purposes of screwing with gun owners at the behest of their masters at the executive branch. That whole thing, yeah, they lost. And they've decided that they're going to appeal that decision. We knew that this was going to happen, and that is the Mock v. Garland case that we have covered here ad nauseum. We kind of expected that would happen. I don't know what the justification for waiting like 2 months was. I don't know if they just were dragging their feet and they didn't know what to do, or if somebody just wasn't paying attention. I have no idea why they waited so long to do it. But we have almost co-located with their decision to appeal this is a decision out of another court, another case, the FRAC v. Garland case. And there's some juicy tidbits in here that I would like to bring to your guys' attention because I think that this judge does a really good job. Mission First Tactical has been a longtime supporter of the channel, all the way back to one of the first products that we ever tested from them. You would recognize them as an accessory company, but they are so much more than that in that they have diversified, offering everything from concealed carry backpacks with armor considerations to cool drinkware and holsters. Check out Mission First Tactical. We have 2 discount codes for them over on the affiliates page. One of them is the all the time everything, and then the closeouts code, which is like 50 to 60% off in some instances. So special thanks to Mission First Tactical for making today's video possible. Kurt, why are we talking about this? I thought this was done. Like, they threw the rule out, man. Like, what gives? We are nowhere close to being done. Remember that the Cargill case, the bump stock ban case, just finished like last month. That was a 6-year litigation process. We're in here for a long haul. Yes, the rule is currently vacated, but remember that all it takes is for the ATF to go cherry pick some court somewhere. I'm sure that they can find one that will agree with them in their infringements on your rights. So if they were to do that, you would find yourself in a situation where you've got one court that says the ATF is doing it right and one court that says the ATF is doing it wrong. And you've got now a conflict between 2 courts and you find yourself between the 2. Do you think that the ATF isn't going to say, well, we got a court over here that says that we can do it and a court over here that says that we can't? What do you think they're going to do? The Mock v. Garland case is out of the 5th Circuit. This case, the FRAC case, is out of the 8th Circuit. And what this does, as far as importance is concerned, is this puts another win in our column. And I've got some juicy tidbits to share with you from this case. One other thing that I would like to say before I get to reading is I did a video a couple days ago about the positives and negatives that Donald Trump has done in his previous administration as it relates to the Second Amendment. And a lot of people got on me for saying that he has appointed some pro-Second Amendment judges. Trump judge. Now, you can say that that was on purpose or that was a broken clock is right twice a day. It's up to you. One of the judges on this 3-judge panel was a Trump appointee, so there you have it. Curtis was right. This is a 37-page document, so I can't share everything with you. Obviously, you can find it very easily across the interweb, and I will take you straight to the conclusion and say that we reverse the order denying preliminary injunction and remand it with instructions to reconsider the motion consistent with this opinion. So they're sending it back down to the district court to say, hey, do your job and do it right. Pay attention to the Mock v. Garland case, as well as pay attention to the Cargill case, which is a major controlling interest in this. And my juicy tidbit that I want to show you guys, if we go back up, remember those super cringe slideshows that came out with the final rule? The coalition also makes two arguments as to the contemporaneously released slideshows. There's a lot of syllables in that one. First, the coalition argues that these slideshows represent final agency actions because they actually judge weapons to be short-barreled rifles. Because the slideshow adjudications do not provide reasoned explanations for weapons classifications, the coalition argues they fail the APA's procedural requirement that the ATF provide a reasoned explanation for its actions. Secondly, the coalition argues that slideshows invents the final rule is arbitrary and capricious because it allows ATF to reach whatever results it wants. We agree with both contentions. The ATF argues that the slideshows are not final agency actions because they have no legal consequences. The slideshows are merely meant to inform members of the public of how they might be impacted by the final rule's future applications. The district court agreed, concluding that slideshows only forecast the ATF's position on particular weapons. But one need not look further than the opening slides of either slideshow to see they represent the ATF's judgments. Both slideshows purport to show photos of weapons that are short-barrel rifles. And the final rule commands that actions, such as registration, need be taken. We take the slideshows at their word. The ATF judged the pictured weapons to be short-barrel rifles, which carries direct and appreciable legal consequences. Even though the slideshows are adjudicatory, they are devoid of any explanation as to how the ATF applied the final rule to the pictured weapons. The ATF insinuates that the coalition bears the burden to prove the pictured weapons should not be classified as short-barrel rifles, an impossible task for anyone, including this court, considering the ATF refuses to give any sort of guidance as to how it evaluates such a factor. The ATF's burden-inverting arguments makes as much sense as shouldering a rifle by the barrel. The reasoned explanation requirement of administrative law, after all, is meant to ensure that agencies offer genuine justifications so that the reviewing court and public may scrutinize those decisions, not the other way around. Accepting contrived reasons would defeat the purpose of the enterprise. Agencies must explain how they weigh factors. Because they lack any such explanation, the slideshows cannot carry the force of law. The irony in this conclusion is that because the slideshows cannot act as judgments, then they exist to provide public notice of how the ATF might classify the pictured weapons, which is what the ATF claimed the slideshows were meant to do in any event. So the slideshows represent no more than the firing of a warning shot. But the above discussion also reveals that the final rule, as a whole, is arbitrary and capricious because it allows the ATF to arrive at whatever conclusion it wishes without adequately explaining the standard on which its decision is based. An agency must defend its actions based on the reasons it gave when it acted. Such explanations are necessary to give guidance on how the ATF is likely to apply final rule in future instances. Thorough, careful, and consistent application of a multi-factor test is important for drawing factual distinctions because appellate courts depend on agency explanations for the performance of their assigned task of review. That the slideshow judge the weapons without explanation reveals the final rule's arbitrary and capricious nature. Thus, we conclude that the coalition is likely to succeed on the merits of its challenge to the slideshows, and the slideshows also advice the final rule is arbitrary and capricious. The ATF claims that it fully intends to follow up the slideshows with detailed classification letters explaining each determination, and that any remedy for proper agency action would be simply to remand any unexplained conclusions to the agency for further explanation and reconsideration. This is much like shooting the side of a barn and drawing the target around the bullet holes and then proclaiming bullseye. Agency actions require contemporaneous explanations and not just post hoc justifications raised in court by those appearing on behalf of the agency or by agency officials themselves. The ATF's act now and justify later decision making is exactly the kind of post hoc rationalizing that cannot sustain its unexplained actions. I don't know. What do you guys think? You think Judge Grasz is trying to take Reed O'Connor to the mat to see which one of them can be more pro-Constitution? I don't know. I think this is the type of competition that we should have in our legal system. This was fantastic, and very few times am I sitting there sipping my coffee first thing in the morning and I read something from a judge from a court somewhere and laugh out loud. My wife was still sleeping in the other room, and I woke her up with a giant belly laugh when I read that crap about drawing the target on the side of the barn after already having shot it. Very good work out of the 8th Circuit. Let me know what you guys think about this in the comment section down below. And remember, the whole purpose of this is to put another check mark in our column so that when this stuff finally makes it up to the Supreme Court, because that's where it's going to go, you know that they're not going to give up. We have stuff like this written into it, so the Supreme Court has to weigh in on it.